All right, I think we'll get started. So good morning, everybody. Thanks a lot for tuning in. This morning we have Ken DeMoura and Paul Robertson from DeMoura Smith. We're going to be talking a lot about contracts and things like that have been affected by the COVID-19 crisis. Paul, Ken, really appreciate you guys coming on and bringing your expertise to us. Really appreciate it.
Thanks for having us, Adam.
Yeah, definitely.
So we're really pleased. I'm sorry, Alex.
Go ahead.
Yep, we're really pleased to be here. You know, Ken and I are trial attorneys and litigators, and you know, that's where our experience is. But this is really a good opportunity for us to share some of the lessons that we've learned, even in the last several weeks, about COVID impact on contractual obligations. And it sounds kind of like a sterile topic, but when you consider that it relates to commercial lease obligations and whether you have a right to enforce delivery of certain product, it really matters. And I think that one of the things that Ken and I really stunned by, to be candid, is that even this late in the game, folks don't have a basic understanding of some of the key issues at play here. And we're able to by talking to clients and spending 5, 10, or half an hour with them to really avoid mistakes that come down the line later when you don't provide notice, or you don't avoid tripping over a simple basic obligation in a lease document. So what we'd like to do is to just really quickly run through some slides, and our presentation today is going to focus on some general concepts, the individual parts of law that we play, and then spend the end of the time on commercial leases. And so I'm going to bring up a screen share here.
Definitely. And just to chime in for the group, we did take some questions ahead of time, and if we have some time, we'll ask a couple of those at the end. But there also is the Q&A box, like the rest of our Zoom sessions. If anything pops up during the conversation, during the presentation, and you're listening, feel free to put any questions in there. I'll be monitoring it, and then after the presentation, if we have some time, we'll do some Q&A. So feel free to take it away, Paul.
So before he does that, let me. Hello?
Go ahead, Ken.
I just wanted to apologize to Alex for calling him Adam a few minutes ago. Sorry about that.
No worries at all.
All right.
So there's the Boston Globe reporting about the pandemic, and nobody predicted this. And the challenge for all of us, lawyers in particular, is we rely upon past events and past cases to predict the future. But in some ways, all bets are off because there is no sort of game plan for some of this. But there are some basic rules and issues here. That's Ken and me in the pre-COVID days. We look forward to getting back again to being in close quarters. We just want to provide a simple hypothetical to explain the terms that are at play here. And so the hypothetical is the St. Patrick's Day Parade. And this is actually based upon the first case in the area involving attendance at a parade. So let's say that St. Patrick's Day Parade is to take place, and you and your party rent the Green Shamrock pub for the day, and everything's going forward, but at the last moment, the parade is canceled, or the pub burns down, or it snows 2 feet. What happens? Do you have a right to rent the restaurant? Does a restaurant have an obligation to provide that service? And the four concepts that come into play here are impossibility, impracticability, frustration of purpose, and force majeure. Impossibility is when the pub burns down, right? There's no more pub. It's impossible to perform the contract, so that may be a defense to performance. Impracticability is when there's economic impairment. So say it snows 2 feet, the parade's still going forward, but the restaurant can't clear the snow but for spending $400,000, or you can't get to the restaurant any longer. It becomes impracticable to perform. Frustration of purpose is if the underlying purpose of the contract no longer exists. So in this case, if the parade is canceled, you paid a premium to rent the restaurant. Can you get out of the contract? And that last one is force majeure, really sometimes a misunderstood concept because it's purely a creature of contract. And it can have any one of these common law principles or none of them. And I'll talk about that in a second. So there they are again. There's a need to understand both sides of the equation. One, whether you have an excuse to doing what you're supposed to under the contract, and second, whether you can compel the other side to perform. And as I mentioned, the force majeure defense is purely a creature of contract. It's either in the contract or it's not. And then the other three, impossibility, impracticability, frustration of purpose, those are implied at law. So the court comes in and says, okay, you folks didn't predict this, but we're going to imply these provisions. We're going to read them into the contract. And keep in mind that first one, force majeure, you can basically write out those other three implied at law provisions. If there's a strong or clear force majeure provision, it may mean that you can't argue the other three defenses because it's addressed by the contract itself. So I want to talk about some general themes that are applicable to all of these defenses in performance obligations. And the first one is real obligation and need to read the contract. You know, folks and clients are typically coming to us and say, hey, what are my rights? What are my obligations? And it depends. The outcomes are very fact dependent, and they depend upon what the contract says. Because every time we see a contract, there's a bunch of ways to skin the cat, and the contracts themselves are as different and varied as your business is. And so, you know, just as those are different, there's differences there, so there's differences in what your rights are. The nature of the intervening disruption is important too. Here, clearly, it's a pandemic, but it impacts people in different ways. The third issue is the party's responsive actions. You know, if one party sits and does nothing in response to the pandemic, but the other party provides notice, mitigates its damages, documents what's going on, it's a much better position going forward. And then the last issue is the jurisdiction. It depends upon where you are. New York has a very different approach than, say, Texas and does Massachusetts to these issues. Plan on consulting legal counsel. And so, you know, as I said before, Ken and I could care one whit if we generate new business from this. We would really encourage you to find some lawyer, some attorney, and develop a relationship with them if you haven't already. And that person, even if they're not a specialist in the issue, can turn you to somebody who is and can help you identify when, hey, look, you know, this is a need to bring somebody on board. Particularly where these issues, there's a lot that can really slide beneath the cracks and under the carpet here. So you need to talk to somebody who's done it before. Understand your rights, obligation, and leverage points. And from the get-go, we encourage communication. We'll talk about this a little bit later again, but, you know, talk. And then read the contract again after you're done doing all this. Once you understand what the other side's position is and what, you know, where you stand, take a look at it again, because things come out that you wouldn't have otherwise seen. And it's not just the force majeure provision that you want to read, it's the entire contract. It's notice obligations, it's default obligations as well. And you want to take the lessons forward, you know, use this as an opportunity to go back and revisit your current contracts, your current lease documents. And, you know, it didn't predict the pandemic this time, but you can't really argue that next time that the pandemic was something that was not foreseeable. There's a well-known case that's going on now, the purchase of Victoria's Secret. And the two parties were negotiating when the pandemic was starting overseas. And one side was particularly clever in protecting itself, and that's having an impact of not millions or tens of millions, but hundreds of millions of dollars in that purchase. Okay, so quickly, force majeure is a contractual provision allocating the risk of loss if performance becomes impossible or impracticable. It's also, in fact, if performance becomes, the contract becomes, the purpose becomes frustrated, it also applies. And it's also applicable if there's a mere delay. And it's generally only applicable if the parties could not have anticipated or controlled what happened. The pandemic is something, and I think we can argue that the party could control, but whether it can be anticipated is going to be a factual question. I just want to make that point once again. It's a contractual defense. It's all about the contract and what the contract says. Its scope, effect, and applicability depend upon the contract's express terms. Again, don't rest in the contractual rights. There's a need to act, to address the duty to mitigate, to observe any notice requirements, and to evaluate the causal connections. It's not enough to just say, hey, the pandemic has happened and I can't perform. How so? Were you forced out of your building? Are you able to mitigate? Are you able to find other sources for what was supposed to be provided to you under the agreement? If you sit and try to bring this defense, months later, you're going to be out of luck. The courts and the law favors those who are acting proactively. Ken, do you want to talk about the next couple of topics?
Sure. Thanks, Paul. So Paul just talked a little bit about the contractual defense or theory that relates to non-performance in a situation like we're in right now. In addition to the contractual defenses or claims that can be made, the law and the courts have, through case law, developed three essential defenses that can be asserted outside of the contract. Their impossibility of performance, impracticability, commercial impracticability, and frustration of purpose. So impossibility, and by the way, all of these defenses, just like force majeure, are very, very fact dependent. And that actually helps, I think, somebody who wants to assert these defenses, because it's going to be very difficult if you're asserting these defenses for the person trying to enforce the contract to avoid lengthy litigation if it gets to that point, because eventually this is going to have to be decided by a jury or a fact finder, and it's not going to be a defense that can be used to sort of knock the case out of the box immediately. They're not going to be able to knock it out of the box immediately. So very fact dependent, all of these defenses. When you're talking about impossibility, you're talking about a situation where there's an extreme or unreasonable difficulty or expense that would be involved if the contract needed to be performed. It does not require that it be entirely impossible, but it has to be extreme and unreasonably difficult, and before you can get relief with this defense. Next slide. The next defense is commercial impracticability, and this defense is somewhat like the impossibility, except it was developed in the Uniform Commercial Code as a way to govern sales of goods contracts. So if there is an extreme or unreasonable difficulty that was unforeseen by any of the parties at the time of the contract's formation, then you can get out of having to perform your obligations under the contract. However, generally speaking, there are cases that say the failure of a third-party supplier to provide whatever you needed to perform is not generally an unforeseen contingency, and generally would not relieve you of your obligations under the contract, nor would changes in market conditions generally be considered unforeseen for purposes of the commercial impracticability defense. That defense also, even though it is sort of codified in the Uniform Commercial Code, has now sort of seeped into applications involving contracts in general, not just contracts involving the sale of goods. And then last, we have frustration of purpose, which is, the next slide. And this is, again, you really need to look at the whole contract, the whole relationship between the parties to determine what was the principal purpose of this contract. Going back to the hypothetical of, your rental of the Shamrock Pub so that you can invite guests and friends to watch the St. Patrick's Day Parade. If that's your principal purpose in renting out that restaurant and the parade gets canceled, well, of course, the frustration of purpose defense is probably going to be a very good one here. But again, you also have to show that your purpose is substantially frustrated and that it's without your fault that it was substantially frustrated. Also, most of the time, the contract has to not indicate whose risk, who's going to assume the risk of something like that happening. I happen to be two of my children are getting married this year, and we're looking at the contracts that we signed with the function halls. And they very clearly lay out who's responsible for what risks. Now, in this case, we've been very, very fortunate to be dealing with venues that have been very understanding and accommodating, because they know they have a lot of brides and grooms who want to move their weddings. But look at the contract, because that may prevent you from raising frustration of purpose as a defense if, based on its language, the assumption of the risk of that lays on you. So those are the three common law defenses. And again, I want to emphasize that they're fact intensive. And like Paul said at the beginning, documenting things throughout this process is going to be very, very important towards whether or not you're going to be able to succeed on any of these defenses. And you're jumping on it immediately and acting in good faith will go a long way in helping you with your case or with your negotiations with the other party to the contract. Paul's going to talk now a little bit more about commercial leases.
Alex and the folks at the Globe were good enough to share with us some of your questions, and we noticed that almost all of them related to commercial lease and commercial lease obligations from the tenant side. And so we prepared a couple of slides to address that. And I'm going to race through these because I have a bunch of points to tackle. And I think my goal here is if Ken and I can't educate you completely on the issues, we can at least help you identify and spot, places where you should be looking and thinking about. Commercial leases, one, read the lease. Again, it's all dependent upon the lease, and they're all very different. And you can give guidance to one client that would absolutely not apply to the next because their lease is different. Consult an attorney, and I've said this before, it bears repeating for the reasons I stated before. But also consult a commercial lease agent or broker, and whether you're from the landlord side, find someone who works from that side. If you're from the tenant side, find someone who favors that side, because they're going to know about the market and they're going to be able to give you guidance as to what other parties are doing and what your leverage points are. If the landlord is not going to be able to find a tenant to replace you now or in a month or a year, that gives you more rights and more leverage points than you otherwise would have. It goes without saying you should be exhausting your CARE Act and other relief options to get as much as you can from those benefits. And I know we could spend another 3 hours talking about how difficult that has been and what the pressure points are, but you should act. So the bad news is that relief of tenants is not likely to be found in the lease. These are typically drafted by the landlords. The force majeure provisions almost always exclusively excuse the landlord from performance, but obligate the tenant to continue making payments, unfortunately. And it's difficult to get around that contractual language. But there are some thoughts here. One is, be aware of the defaults. Take a look at the lease in entirety. It sometimes has, for example, obligations to occupy the premises or obligations to provide notice when you're not going to make a rent payment. So take a look not only at the force majeure provisions, but the lease holistically to see what you should be doing. Again, heed the notice obligations. And with your attorney, think about anything outside the box. For example, you're excused from paying rent if there's damages to the premises, but there are some who are stretching that to argue that, look, if the premises are shut down, that may constitute damage. Or, for example, the landlord has an obligation to make sure that the premises are free from, quote, hazardous substances, unquote. Well, there's a strong argument that if it's COVID infected or the risk of a COVID infection, you may have a right to argue that that there are no hazardous substances, that there are hazardous substances present. And again, there's no law on a lot of this stuff. Nothing's been decided, and it probably isn't going to be decided for a couple of years before it reaches the final resolution by the courts. But these are pressure points and arguments you can make. In Massachusetts, there's been an eviction foreclosure moratorium that was announced on April 20th. The landlord may not commence an eviction action. Probably couldn't anyway because most of the courts are closed. That's through at least August 18th, 2020. It applies to only, quote, non-essential, unquote, evictions. That means it has to be COVID related. If you are, and I saw this was one of the questions, if the lease is simply terminating on its own, you probably can move forward to remove the tenant. If it's COVID related, that it's been caused by the pandemic, you probably can't move forward. and applies only to small business premises units, as that is defined. Your business has to operate only in Massachusetts, nowhere else in the country. It has to be privately owned, and it has to have 100 and fewer employees or fewer. It has specific notice obligations. You have 30 days to act under the law to provide notice that you're seeking to take advantage of the act. It provides no relief from the rent obligation itself. And then final, it also has relief for mortgage payments for the landlord themselves. For some landlords, they have to own 4 units or fewer on the premises. So there may be a place where the landlord themselves are being forgiven for their mortgage payments, and so there may be room for you to get relief on your rent payments. Negotiation options: act now and be proactive and be prepared in your negotiations. Know the lease rights and obligations first. Don't go in with the questions to your landlord. Understand the market. Support your position with records, namely show what your finances were before and afterwards, show what the impact of COVID is, and talk about what your plan is going forward as much as possible and with as much detail. And provide a concrete proposal. Are you seeking an abatement, a reduction, to defer the rent? Do you want to propose them using the landlord using the security of the last month's payment? And then have fallback positions ready. If they reject abatement, maybe you can get a reduction or a deferment. And I would encourage to call on the phone in the first 4 if you haven't been having those discussions. So much of this is tone of voice, and you can diffuse things by a phone call. Oftentimes, property owners are themselves in difficult positions. And be transparent. You want to be careful, of course, to protect your rights, but there's no reason not to be candid. We're all in the same boat here. You want to consider evaluating what the landlord's position is. Do they need lender approval, for example? They may be restricted as to what they can do. Are they taking advantage, and can they take advantage of the law providing a moratorium? And whatever you do, put it in writing, right? If you reach an agreement orally, make sure that you can confirm that in writing. And consider the hardball option, right? You can bring the attorney on earlier on in the day to communicate with their attorney. And sometimes Ken and I have been very successful in reaching very quick resolution by playing good cop, bad cop, and rather than having to spend lots of money later in litigation, reaching a resolution very, very quickly. Business interruption insurance, I'll just hit this quickly. Most policies are not going to give you protection for small businesses. They specifically exclude pandemic coverage, but there's talk in the legislature about changing the law in Massachusetts and possibly at the federal level to obligate insurers to pay. I don't think we can rely upon that. It's sort of kicking around at the State House now and on Capitol Hill, but they at least pay attention to that, whether there'll be an increased opening of the door with respect to your ability to claim business interruption coverage. So just some quick practice tips. We've hit these. Let's leave the time for question and answers, but be proactive, record your steps, provide notice, communicate, and prepare for the next time. You know, this is the pandemic, but climate change and terror attacks may be the next one. Take a look at your contract and revise them as necessary.
Awesome, guys. Thank you so much for that. We had 2 good questions come in. We also have a couple that were submitted before the presentation, so we'll try to get to as many as possible. One good question that came in is about colleges. This person's son is scheduled to attend in the fall of 2020, but at the college only opens under a distance learning format. What is the parents' or the students' rights in terms of tuition and things like that?
Alex, is the question for next year?
For the fall of 2020.
Yeah, so for the fall, I mean, that's pretty clear to me. It's like, you know, they can choose to take advantage of it or not take advantage of it. You know, we're seeing, we have a couple of cases now involving tuition payments for this year. And schools are, you know, starting to move forward, giving back room and board for special needs students as a move towards providing discounts there. But for next year, there's some talk too about whether, you know, colleges could be potentially liable to early. But I think for the most part that if it's distance learning, it's a bargain you make. If the school offers a tuition payment and they're going to provide distance learning, you make your choice.
Gotcha. So the other question that came in was about insurance. I know you just were talking a little bit about that. Any more kind of detailed advice? This person owns a restaurant. so some of them are open for takeout or delivery only right now. In terms of enforcing insurance, any more thoughts specifically for the restaurants that are kind of half open right now?
Well, I think if they're open, if the question relates to sort of, can they apply for business interruption insurance, or is this a liability question? I'm not sure, but I'll just broadly say, number one, you want to obviously get your entire policy, including all endorsements and exclusions. A lot of people have their agent will send them the cover selection page, but they don't have the whole policy. So you want to get that. You want to read it through. You want to work with your agent or your broker and find out, because hopefully you're using an agent or broker who has experience in your industry. Find out what the pressure points are, how to characterize the claim. For example, a pandemic or a business interruption policy that doesn't cover a pandemic may cover your inability to get product from your supplier. And so you don't want to be putting in your business interruption claim that you have a pandemic claim. You want to say that I have a claim because my supplier isn't supplying me with what I need to produce my product. So see your brokers, get your policy, talk to your agents and brokers, consult your attorney, and also be very careful about how you characterize your claim.
Gotcha. We just had another question come in. If our business fails without a declaration of bankruptcy, are we done with the commercial lease if we have not signed a personal guarantee?
Well, no, I don't think so. No. Even if you haven't signed a personal guarantee, you're still, unless the company has gone bankrupt, there's, the company has an obligation to pay the rent. I mean, there's the legislation prevents the eviction from happening, but it does not prevent the basic commercial obligation that you still have.
Well, I think if the question is, are you personally liable as an owner of the business? If you have it set up as a limited liability company or a corporation, then the only assets that the landlord is really going to be able to go after are the assets of the entity, not your personal assets. And if not filing for bankruptcy, if there are practical reasons why you wouldn't want to do that as a business, talking to the landlord about the fact that, look, we are on the doorstep of filing for bankruptcy, and if you push us into bankruptcy, of course, the tenant is going to have a lot of rights in bankruptcy, including the right to reject the lease. So I think there are ways to use it. I think it isn't going to prevent the corporation or the business from having that obligation if the landlord was to try to chase the business, but they would be limited to whatever assets the business has. There may not be many assets. And so, but also be careful about getting rid of or paying certain creditors over other creditors, because then there could be an argument that you're favoring one creditor versus another.
And to add to what Ken just said, I mentioned that in the beginning, there's a need for a phone call to try to develop a rapport. I don't want to overstate that, though, because there's also a real need to document what you're doing. Because eventually, if things fall apart and the landlord continues to play hardball, you want to have documented you've taken an extremely reasonable position, because they're going to be not ones or dozens, but scores and hundreds of these cases making their way into courts or before administrators at some day in the future. And if the landlord was unreasonable and you made all kinds of concessions and proposals and none of them were accepted by him or her, you put yourself in a much better position if you've documented that, hey, look, I took this position, I tried to explain myself. The case is going to be heard by a human being on the other side, and it benefits you, especially in this situation where we're all in the same boat, to be reasonable and documented.
Gotcha. All right, we have time for probably one or two more. A question around deposits for events, which was kind of more towards the beginning of the discussion. Are deposits for events treated as the same as apartment deposits, i.e. 30 days if there's nothing mentioned in the contract specifically?
No, that's a Massachusetts statute that applies specifically to landlord-tenant obligations, but there's nothing that talks about what happens in the event of an event. And a lot of that, again, Ken and I have already handled a couple of cases on that, and it's what happens is that these contracts are drafted without people thinking. You can't possibly think of what a pandemic might lead to, and if you know. It's kind of like that exercise we all did as kids where you wrote instructions on how to, make a peanut butter and jelly sandwich. But then when people tried to follow your instructions, they couldn't because, it's the devil is lost in the detail. So many of these contracts, they have language, but it's a complete mystery as how it applies in certain circumstances. So here again, with respect to events, take a look at the contract, and then usually both sides have leverage and arguments to make on it because oftentimes the language did not at all anticipate what is happening.
Gotcha. I think what would be helpful is, would you guys be able to provide your website, contact information, so people have more specific questions to either their industry or business? Where can the attendees reach you to kind of follow up?
Sure. I think if Paul may have even included it as the last slide on the presentation.
Great.
Let's double check. Is that right, Paul? There it is.
Yep. I think I've just put it up there. Do you see it?
Yep.
Yep.
We'll be sending out a recording to this. So obviously this screen will be up there. We can also see about potentially sending some of the slides if you guys would be comfortable with that. Send that way.
I think you can send the whole package, send the whole slide deck.
Awesome. Because there's just so many challenges for so many different types of businesses during this time. So it's, appreciate your guys' time this morning, being a resource for the small business owners. But it would be great to see, some continued relationships and dialogue so that they can learn, you guys can learn, what's going on. And it's just a win-win for everybody. So any closing thoughts, anything like that you want to share with the group that's front of mind that maybe we didn't get covered in Q&A or presentation? Can
I say this, Alex? I just want to really applaud you and the Boston Globe for doing this. That, Ken and I, we're a small business. And, this for us felt really good to be able to offer our guidance and our advice and, to be able to provide, these lessons that we're learning awfully quickly. But for the Globe and for you to set this up as a means to communicate quickly and effectively, because there's just so much, for lack of a better word, BS out there and junk information that, to be able to turn to you folks in the Globe and to be part of, for you to permit us to be part of that conduit to provide reliable information really makes us feel good. So thank you very much.
No, absolutely. Happy to have you guys. This was great.
Thank
Ken,
you.
Closing thoughts?
The closing thoughts would be the same thing we've sort of said all along. The earlier you get, and you get your hands around this by getting your documents and reviewing them and being proactive versus thinking that something, this is all going to be taken out in the wash someday, the more likely you're going to be able to meet the objectives you want to meet and the goals you want to meet and get the result you're looking for.
Definitely. Well, like I said, we'll be emailing out definitely the recording, probably the slides as well for everyone who RSVP'd or wasn't able to attend. Paul, Ken, really appreciate it. I know I learned a lot just listening and watching you guys. So appreciate your time. Happy Friday, everybody, and stay safe.
Thank you.
Thank you, Alex.